From choir to debate to theater, SDPB shines a spotlight on South Dakota's talented students through SDHSAA All-State Fine Arts programming. Good, useful, and full of wonder. SDPB. Every day, SDPB connects South Dakotans with stories that inform, inspire, and bring us together. SDPB, good, useful, and full of wonder.
Order. It is 1:30 p.m., June 24th, room 413, the State Capitol Building. This is Chairman Nelson. I have with me Commissioners Hanson and Fegan in the meeting room. We are here today to deal with docket GE 25-001 in the matter of the joint application of Northwestern Energy Public Service Corporation, Black Hills Corporation, and Northwestern Energy Group, Inc. for approval of merger. The questions today: shall the Commission grant the joint motion for approval of two settlement stipulations and stipulation for the entry of all pre-filed testimony and exhibits, and shall the Commission approve the joint application for approval of merger, subject to the terms and conditions stipulated to by the settling parties, or how shall the Commission proceed? And so I think what we'll do, we'll give Black Hills an option. If there's anything you want to add to today in Northwestern, and we'll go to the interveners and then staff, if there's anything quick you want to add. And then we'll also ask questions. Well, Black Hills.
May.
Yes. And if you had hit that button,
Yes,
there we go.
Green means go, red means stop. Good afternoon, commissioners and members of staff. First, I'd like to say thank you all for the time today. Thank you for the work that we've done on this docket. My name is Kathy Sabers, and I represent Black Hills Corporation in this matter, and I'm here also with Sarah Norcott, who is representing the Northwestern parties. Today, joint applicants are happy to be presenting the commission with two settlements which resolve all contested issues in this docket, and we ask that you approve those settlements and approve the merger. Last August, joint applicants announced that they had executed an agreement to merge. The transaction is a stock-for-stock merger with no incremental debt, no transaction costs, and no cash exchanged at the time of close. In October, joint applicants filed the pending application for approval with the Commission pursuant to SDCL 4934A35 and 4934A36 due to an upstream change of control over Northwest Energy Public Service Corporation. Under South Dakota law, the Commission shall approve the merger unless it finds that there is a likelihood of significant adverse impacts to South Dakota customers. In our filing, joint applicants presented testimony and supporting documentation from 5 witnesses demonstrating that this legal standard was satisfied. Joint applicants explained that South Dakota customers will not experience increased rates as a result of the merger docket and that service quality will not decline. Joint applicants further explained that Northwestern and Black Hills Power will remain separate operating utilities after closing and will continue to provide customers with the same high-quality service experienced today. Finally, PUC oversight and regulatory authority remains unchanged, with the Commission having continuing jurisdiction over the rates and services provided to South Dakota customers. These same witnesses described the opportunities that the merger will bring to South Dakota. The opportunity for scale-driven financial strength and increased access to cost-effective capital, the opportunity to reduce costs in ways the individual entities cannot do alone, and the ability to leverage the best practices of 2 South Dakota utilities with over a century of operating experience in this state. Through discovery, staff did raise some concerns relating to the transaction, and joint applicants and staff negotiated in good faith to address staff's concerns. The comprehensive staff settlement underscores the conclusion that this merger can and should be approved. That settlement memorializes many of the commitments made by the joint applicants in their initial filing, while also providing ratepayer protections, additional transparency, and assurances regarding our continued local presence. LIUNA has not opposed the staff settlement, and subsequent to the staff settlement, joint applicants reached a comprehensive settlement with the only other intervener, LIUNA. Staff has reviewed the LIUNA settlement, and they do not oppose it. This is demonstrated by the joint motion for approval of 2 settlements filed on June 17th and executed by all 3 parties. The LIUNA settlement sets reasonable third-party contracting commitments which are flexible and can be implemented without undue administrative burden or customer impact, and which resolve all of the disputed issues between joint applicants and LIUNA. Here today to answer questions from the Commission are joint applicants witnesses Brian Bird, Marnie Jones, Crystal Lale, Tom Stevens, and Blue Lefebvre. Available by telephone if necessary are Kimberly Nooney and Michael Pogany. In summary, there is no likelihood of adverse impacts to South Dakota customers, let alone a significant likelihood of adverse impact to South Dakota customers. Instead, the merger is a straightforward holding company transaction that preserves existing utility obligations, rates, and regulatory oversight while providing greater scale, financial strength, and long-term opportunities for South Dakota customers. Given this, joint applicants ask that the Commission approve the settlements and approve the merger. And with that, I would turn it over to Ms. Norcott.
Thank you. Yeah, we'll hold questions till the end. Northwestern. And I should have mentioned we have our star court reporter with us today, so make sure we're speaking slowly enough for her to capture everything.
Thank you, Chairman. As Ms. Sabers mentioned, my name is Sarah Norcott, and I represent Northwestern in this matter. And on the phone is Shannon Heim, who also represents Northwestern in this matter. And we wholeheartedly agree with Ms. Sabers' comments about the merger, and we would similarly ask that the Commission approve both settlements and the merger. We would like to thank the commissioners, the staff, and the interveners for the hard work that went into this case. And we are really pleased that we were able to present the Commission with 2 comprehensive settlements for your consideration today. We look forward to your questions, and with that, I'll turn it back over.
Thank you. Interveners.
Yes. Are you taking public testimony at this time?
No, we are not at that point. We are on interveners and Mr. Taylor.
Thank you, Commissioner Nelson. William Taylor, appearing before the commission for the 4,000th time, representing Laborers International Union of North America. It's Local 620, that is Sioux Falls-based South Dakota local, and its regional management arm, the Great Plains Laborers District Council. Laborers International Union of North America, commonly known as LIUNA, has about 550,000 members active throughout the United States. Those members provide construction services in a wide variety of disciplines, have a strong relationship and involvement with public utilities, both in gas pipeline construction, in the construction of generating facilities, and in the maintenance of generating facilities. LIUNA, the Montana LIUNA local provides Northwestern Energy Services in its maintenance division at its coal strip generating facility, and has worked on, LIUNA members have worked on Northwestern projects throughout South Dakota and the other areas in which the company is active with its gas business. LIUNA has reached a settlement with Northwestern and Black Hills after a good deal of negotiation. I'll tell you that the settlement is patterned on and not materially different from settlements that were arrived at in Montana and in Nebraska, and accepted by the Nebraska Commission. The acceptance of the Montana settlement is still pending, but my colleagues can speak for this as well as I can. I don't think there's much question but that the settlement will be accepted in Montana. I do not have my client with me today, but if you have questions that I cannot answer, he's available by telephone on standby, and I'll call him. So we'd ask that you approve the settlement today. Thank you.
Thank you, Mr. Taylor. And just for public note, according to our agenda, public comment is at the end of our agenda today. And so with that, we will go to commission staff.
Thank you, Mr. Chair. This is Logan Shapar for staff. We were able to reach a settlement with the joint applicants that, if approved, we believe removes any likelihood of significant adverse impacts to South Dakota customers. We would simply stand by the memo that we filed and request the commission approve the settlements and approve the merger. Thank you.
Thank you. With that, questions? I do. I'm waiting for you. Okay, apparently I get the first crack. For staff, obviously we don't do mergers every day. I've been here, I don't know, 16 years, and I don't think I've done one, so these are unique. And so I'm guessing that the issues that are involved in evaluating a merger, according to the criteria that's laid out in state law, are something that staff, you know, it's novel. And so did you reach out to other commissions that have done this kind of thing, to other experts? I know you've got a consultant on the line. Help us understand what kind of expertise you brought in to help you do the evaluation and come to a settlement that you believe protects the people of South Dakota.
Thank you, Mr. Chair. This is Logan Shapar for staff. We did retain a consultant for this matter. We relied heavily on his expertise. We also kept a close eye on the proceedings that have been going on in Montana and Nebraska. So that's a lot of the review that staff went through in this matter, and I don't know if our consultant, Mr. Paff, wants to add to that, but that's what I have.
Well, I think I will go to Mr. Pfaff, and if you can just maybe share with us your expertise in the merger area so that we have some understanding of how you were able to assist our staff in coming to this resolution.
Sure, and thanks for the question. Yeah, I've reviewed several mergers over the course of my career, a number in Maryland, one in Delaware, one in Missouri. And you're correct, they don't happen that often. They are happening more since the KUKA legislation was changed in around 2005, but they're still fairly rare, and obviously they are very significant transactions, and they have a lot of impacts, both direct impacts to the utilities, obviously, but then indirect impacts to the customers. And so when I began reviewing the merger in this particular proceeding, and as I would do in any merger proceeding that I was involved in, the initial my initial objective was to understand what the statute governed the merger, because that impacts my analysis clearly. And I can tell you from having worked in several other jurisdictions and reviewed the merger cases and even more, that the statute in South Dakota is fairly unique in the sense that in most jurisdictions you have either a public interest standard or a no harm standard. In South Dakota, it's a likelihood of significant impacts to South Dakota customers. That's very specific, and it's a fairly high threshold to reject the merger. And so my that colored the analysis that I did, and that allowed me to, or knowing that statute allowed me to focus on just the areas of the merger that I thought had a potential to cause a significant adverse impact. And so it was a narrower scope because of the way that the statute was written. And so, that, that, like I said, that framed my analysis, and that was the initial task that I did. And then from that, I started to look at, okay, well, what are the potential consequences of this merger that could cause a significant adverse impact to South Dakota customers? And those are essentially what we've negotiated in the settlement. The risks that we identified, the settlement mitigates those. So cost allocation impacts, transaction costs, et cetera. I won't go down the whole list because I know you've read the settlement, but that initial framing of, or that initial read of the statute framed how I performed the analysis. And then from performing the analysis and identifying the certain risks and potential harms, that's what led ultimately to the settlement. Hopefully that helps, but I'm happy to answer anything else.
That helps greatly, and frankly gets Logan off the hook for the next question I was going to ask him. And that's the fact that the statute that we have to operate under is different than other states. And so if folks out there are comparing what this commission is going to do here with what other states do, you really can't, because the statutes are different. And in this case, the statute says we shall approve unless we find the likelihood of significant adverse impact to customers. And as Mr. Pfaff talked about, that's where you focused appropriately, and where you found areas that there might be risk of that, you put provisions into the settlement to protect against that. At least that's my observation. And so I appreciate Mr. Pfaff, I appreciate staff doing that type of analysis on this. The only other question I've got, and Mr. Taylor, I'm going to ask you, and if you need to defer to Mr. Harris, you can, but if you'd come up and so it's no secret, Laborers Local 620 ran a significant number of ads recently and about this merger. And their question was, if we approve this merger, who benefits? Billionaires or South Dakotans? And so my question is, who are the billionaires that your client is referring to?
Well, perhaps it was an offhanded reference to the stock benefits that accrue to the officers and executives of the company, or perhaps the investors. I did not author those ads, and I cannot say that I adopt those ads as my own statement. And they're not evidence in this case. True. What they are is an effort to persuade the public that there is a public interest in paying attention to this merger. Frankly, Commissioner, I was surprised in the fall of 2025, when the petition was filed, that LiUNA was the only intervener. I fully expected, when I knew that the merger filing had been made, and I fully expected that there would be public interest groups and other groups that would intervene, if for no other reason, to seek a definition of the standard, a legal definition of the standard that applies to the commission, and for number two, to support staff and Mr. Schaefbauer's efforts to craft a set of limitations that would make sense in the public interest in South Dakota. We had some discussion in this case about whether or not public interest plays a role in the standard for the commission's decision. I would have loved to cross-examine Mr. Pfaff on the issue of whether or not public interest plays a role, because despite what he said in his testimony, indisputably every governmental decision fundamentally has to be in the public interest or it's unconstitutional. I think the point that LiUNA wanted to make with its advertising was we need to pay attention to the public interest. And they had some concern that we would not achieve a settlement. It's not evidence in this case, but the settlement came at the last hour after many months of back and forth discussions. I didn't know Ms. Norcott prior to this proceeding, but I've known Kathy Sabers for a long time. Both are reasonable people. Both represent companies that have a long history in South Dakota, and it took us a while to get to where we wanted. LiUNA thinks that the settlement that it proposed and the settlement that the staff proposed are in the public interest. Had they not achieved a settlement with LiUNA, we'd be up here talking about the public interest, loud and long.
And that would have been fine also.
Would have been fun.
Yeah, I agree. So ultimately then, because your clients did come to a settlement agreement with Black Hills and Northwestern, whoever these unnamed billionaires are, apparently your clients are okay with how they might benefit. Is that correct?
I would say yes.
Thank you. Further questions, Commissioner Fegan?
Thank you. Commissioner Nelson, I'll never forget in August of 25 when you came and told us we better start learning AI. And you probably remember that. Yeah. So at 8 a.m., was my very first question in August, and I asked AI because Wall Street learned of the merger. My very first question was, does the Black Hills Energy and the Northwestern Energy merger benefit customers? AI came back, Commissioner Nelson, and said they didn't know yet because they didn't have enough information. So that was my very first question to AI in my entire life. My first question is for staff, and it's really the analyst. Tuesday, we had a lot of exhibits filed, and want to know, because you guys spent a lot of time prior to that, and you gave us a settlement April 29th, which was detailed, grateful for what you guys did, because like Commissioner Nelson said, we don't have, we have very limited authority in a merger, and the bar is very low to add anything to it, and you guys added a lot. My question is, were you able to obtain a lot of your data requests and like all the information we got like Tuesday night? Did you have that information well in advance so your team and your consultant could review it?
Logan, I'm not sure if you want me to take that question, but I'm not certain what documents are being referred to.
The exhibits by Black Hills Energy and Northwestern that were filed in for the evidentiary hearing.
This is Eric Paulson for staff, and I think if you're referring to the data request documents, the first data request, DR1, we asked, in my emails I see we had, I think, everything by like January 12th, and DR2 looks like March 23rd. So we had them for quite a while, and we had multiple discussions with the joint applicants about the substance of those and other meetings that we had scheduled.
Great. So I'm the only one that had a heart attack Tuesday night when I arrived after our RTO meeting at about 11 p.m., was at the Capitol following up with emails and saw the exhibits and said, oh my goodness, how am I going to prepare for evidentiary hearing with all my Post-it notes and all my questions and making sure the record is going to be good to be withheld at the Supreme Court?
So you wouldn't have had as much fun as Bill Taylor and I would have had? Is that what you're saying?
Not over the weekend. No, I wouldn't have. So I'm glad you got them in advance, and I'm glad that you sent the memo canceling the evidentiary hearing before I started studying, so thank you. The golden parachute, that question is for staff. In any type of rate case, isn't that normally stakeholders' cost, or not, yeah, shareholders cost? Or have we ever, do you know, in any rate case, have we ever funded a golden parachute? Because I'm so thankful it's in this settlement that you're aware of.
This is Brittany Malhoff for staff. I am not aware that we have.
Okay, thank you. Because otherwise, I was going to ask the time of that golden parachute to Northwestern and Black Hills Energy, but I don't think we've ever done that. So thank you for putting that in the document, and I don't think the commissioners would ever probably approve that in a rate case anyway, and neither have the staff. I do have a question for Brian Bird. Surprise, surprise, Mr. Bird. Welcome. So everybody in this whole room probably knows the question I'm going to be asking. When I read your testimony, on page 9 of your direct testimony, you talk about customer service.
Yep.
And so you knew, you're probably prepared that Commissioner Fegan's going to ask about customer service.
Indeed.
And you know that I have no authority by law to require any type of what you do on customer service. I have reliability, cost, affordability, but not necessarily customer service. So I have visited Northwestern's service centers, several of them, where customers can walk in and talk about a bill. The two companies differ in their ideas of providing face-to-face contact. So although I have no authority, and we don't have any authority, tell me about your plan on customer service, because you did mention it in your direct testimony.
Yeah, one thing I should mention too, and Chairman Nelson mentioned that there's not too many of these transactions from a merger perspective in this industry. One thing different between a merger and an acquisition, you kind of come in and you just tell people this is the way it's going to be and we're going to make these changes. We're the acquirer and this is how it's going to be. When a merger, you need to talk to each other. You got to figure things out as a collective group and make the best decisions for the combined entity. We certainly like our walk-in offices. I think that's particularly what you're asking about, Commissioner. But at the same time, we have to understand holistically, from a customer service perspective, what does Black Hills do well and what do we do well, and jointly make decisions and do that in a cost-effective way to move forward. On day one, I will tell you right here and now, we are not planning to make any changes from a customer service perspective. You will still see on the eastern side of the state Northwestern Energy attire on our folks and signage. And on the western side of the state, you're going to see Black Hills. And the reason we're doing that, we don't want customers to be disrupted right away to say, who do I pay my bill to? You know, we want to have time. And I believe over time you will see Bright Horizon signage at some point in the future. But we want to make sure we don't disrupt customers on day one from a customer service perspective and give us the time. And we're obviously, matter of fact, Bobby Schropp was telling me today that the customer service folks have been talking about these various aspects in terms of what we each do. And we're learning from each other, and we may even pick a third path, right, as we talk about these things. So no decisions have been made yet, but we need to think about that customer service. We know you appreciate it, and I know our customers do. And so we have to think about all of those factors and make those decisions down the road. But I can tell you, as I sit here today, no decisions have been made on that front.
Do you two have any questions of Mr. Byrd while he's up here? Go ahead.
So continuing this line of discussion, I mean, my understanding is if the merger takes place, we're still left with two operating companies, Black Hills and Northwestern, and they may be operated differently, not only in the near term, but even in the long term, or are you thinking that wouldn't be the case?
Yeah, I think it's a great question. I think, from an organizational standpoint, legal entity standpoint, even from a filing rate cases, it'll take probably some time to some point in the future that it's all one big entity making a rate filing, if you will. That may take time, and we may not do it because they are set up separately as legal entities today. But from an operational standpoint, we're going to want to have best practices. We're going to want to ultimately do things consistently between our utilities. That's where the benefits ultimately are going to accrue to customers. Let's take the best of what we do collectively as two very, very good utilities and provide that service to our customers. Having consistent practices, that won't happen overnight, Commissioner, but I do believe it will happen over a period of time. We think about transitioning to a target state kind of in a 2-year time horizon. Think about technologies that we have to, and from a billing standpoint, we may have 2 billing systems for a period of time because you just can't necessarily put those together overnight. So it's going to take us some time to ultimately transition to where all the practices are consistent between the two companies.
I appreciate that discussion, and I would echo Commissioner Fegan that as you are evaluating this customer service perspective and figuring out who does it better, Northwestern does it better. No offense, Northwestern does it better. That's our objective evaluation, I think, from listening to customers for a lot of years. And so if you can bring that perspective over, I think that would be helpful for the Black Hills customers.
appreciate your feedback.
Is it, you talked about maybe this two-year horizon of bringing these two operating companies together. It's your understanding that if that were to happen, that would require approval again from this commission?
What I'm saying is from a legal entity standpoint, if we set up a brand-new legal entity that in our filings are associated with that, I think that would be something that we'd have a different approval of. I just believe that it's easier, and we probably need to get someone from the regulatory group to maybe better answer that question. But I do think from our perspective, the way right now a Black Hills entity is making filings for a rate review perspective, and we are doing the same thing here. We're all going to report up to Bright Horizons, which will be a Black Hills entity that will be renamed Bright Horizon, right? We'll still have Northwestern Corporation and Northwestern Public Service, and that's likely who's going to be making your rate filing. For us to actually kind of take these entities, merge them together, I think that's going to require some sort of approval would be my guess. So my expectations, we wouldn't do that for some time.
Okay, and that's our understanding also, and I think I make that point simply for the folks out there that are listening, that there's some understanding that if there is going to be that joinder at some point in the future, and I make no determination whether that's good or bad. I mean, we'll figure that out at the time, but that the commission will in fact be part of making that decision if you decide to at some point. That's the question I've got for Mr. Byrd. Yeah.
I'm going to ask staff first. So staff, in the settlement, it talks about on several of the items that they will notify the commission, informational filing, annual filing to the commission. Is that something that the commissioners will see all of that? So when you say the commission, that means the commissioners on all of that, including the annual filing? So I saw a lot of that. I'm assuming it is, because otherwise the lawyers or...
Commissioner Fegan, this is Logan Shapar for staff. Our understanding was that this information would be available to the commissioners, probably filed in the docket.
Good answer. Thank you, Logan Shafbar. Gets you off the hook, Mr. Byrd.
Commissioner Hanson.
Well, I liked everything about this agreement. I think I liked everything about the agreement. As I read it, I was impressed. I've read a lot of legalese in my life, and as I went through it, I was imagining for all the different negotiations I've gone through in previous life, I thought, wow, this involved a lot of people, a lot of opinions. It went up the ladder, went down the ladder, it went this way across the horizon, bright horizon, I guess. And as I went through it, I was saying to myself, I wonder how they treated this, I wonder how they treated that. And I was very impressed with the semantics and the way it was all came together for me. There are a couple of questions that I have. One does involve the golden parachute, and forgive me on that, as I didn't make copies because actually I read a lot of this from my phone at home. And in that sentence, there was a descriptive word. I don't remember if it was an adjective or an adverb, but it followed a sentence, almost seemed to be a compound sentence. I had to read it 2 or 3 times, and it seemed like I'm not confusing it with the ring fencing. You're not confusing it with the what? Ring fencing, ring and fencing. but it seemed to clarify, and possibly the semantics of it changed it a little bit for me in my mind. And I was just trying to look it up again, and I didn't find what it referred to. You happen to have found that? I know you were looking. Excuse me, did you find it? Thank you. Ms. Edwards pointed out that I might be thinking of the ring fencing. Sarah, excuse me,
Yes, Commissioner.
did you find something?
If you look at, well, in Section 8, Part C is what talks about the golden parachutes in particular, in that the joint applicants agree not to recover golden parachute change in control and/or severance costs.
And well, just assure me that it does not affect the ratepayers in South Dakota, the payments for, obviously, we don't need to know anything about the golden parachutes other than it does not affect the costs to the ratepayers of South Dakota.
Thank you for that clarification, Commissioner Hanson. Yes, by excluding them for recovery, we cannot seek them in a future rate case from South Dakota customers.
Thank you very much. I appreciate that.
Can I ask a follow-up on that?
Go ahead.
I heard you say that you would not recover those in future rate cases. And is it also true that you would not use current operating money for any of that under currently approved rates?
Mr. Chairman, that's my understanding, but I would probably defer to Ms. Lael to speak directly to that, but we wouldn't recover those from customers because those will be recovered from shareholders.
Well, you're already recovering operating money from customers. I just want to make sure that it's not going to go for any of these purposes. So, Ms. Lael, you're, and I apologize, but I think this is, we need to make sure. You understand my question?
Sure. Crystal Lell with Northwestern Energy. And the question I would clarify to the golden parachute term or any of these are, just so we're all clear, only occur if someone leaves the company. So you're exited. So these are payments occur if someone no longer continues with the combined entity. And so the question is that shareholder dollars or not? The settlement in front of you is clarifying we can't seek recovery, and those are essentially shareholder dollars to cover any of those costs related to the merger.
And that you would not also use currently approved operating money for such?
Right, and the way I would...
And would that be true for both Northwestern and Black Hills?
Yeah, the way I would think about that, Commissioner Nelson, is the operating recovery we have today is based off historic rates that absolutely did not capture that. These are shareholder dollars to cover merger sort of transaction costs, so that would not be reflected from that.
And you made clear that this is only referring to people that would leave the company. Are there going to be company employees that will receive bonuses if this merger is approved that would come from from ratepayer dollars?
There is no merger bonuses per se. There are retention awards, obviously a lot of uncertainty for our employees, and that is also clarified in the settlement that those are not to be sought recovery of.
Thank you. Go ahead.
Thank you, Mr. Chair. Additional question would be on ring fencing. The verbiage pertained to that it included ring fencing, I believe the word was protections. So to me, that doesn't mean that it is completely ring fenced, and obviously South Dakota law requires ring fencing on, and I'm not certain from the standpoint of the coordination of whether subsidiaries or how it's related. So I'm seeking information pertaining to making certain that under South Dakota codified law that the agreement for the unification, the ring fencing does qualify under South Dakota law. Because I didn't see any, I may have misread as I was going through it. I didn't see where the board of directors had to be different people. They could not have the same person, a member of the board of directors within both utilities.
Commissioner Hanson, I don't know that I am the right person to speak to South Dakota law. So I will speak to the ring fencing as I understand it. So Northwestern Energy reorganized as a holding company a little over 2 years ago. And the ring fencing that we put in place in that docket, in my understanding, comported with South Dakota law. As a part of this transaction, we came in, and obviously that was approved in a separate docket. We came in and proposed to keep that ring fencing as is. We obviously engaged in a conversation with staff. Staff had questions and wanted additional protections on top of that. So while we believed there was reasonable ring fencing in place when we made the filing that would have comported with South Dakota law, and again, I'm probably not the right person to answer the legalities of it, there's additional measures captured in the settlement agreement that staff felt were important, and fairly so, with regard to credit ratings and dividend structure to provide additional protections. So I would suggest to you the stipulation provides enhanced from what was in place upon filing, and once we close would be in place then.
Sorry, just slow down a little bit.
Yes, sorry.
To you, the stipulation
Provides enhanced ring fencing rules that are important for appropriate protections that staff felt were important and subject to negotiations. With regard to the specifics of your question on requirements of board members, that I actually don't know off the top of my head. So I don't know that I can answer that piece of it.
Thank you for your answer. Ms. Norcott or Ms. Sabers, do either one of you have something to share with us on this?
I was just going to maybe clarify and put a finer point on it. We're subject to South Dakota law today, and we comply with all those rules and regulations that are inherent in the law. And as Ms. Whale said, I think these just protections should be viewed as enhancements. They're over and above the requirement of South Dakota law, and certainly they don't take away any of the inherent rules that we have to abide by today.
Thank you, Ms. Sabers. Appreciate that. The other questions I had appear to have been answered, with the exception of Mr. Taylor. I'd like to ask him one question. I seldom get the chance to call you Mr. Taylor.
Thank you, Commissioner. Fire away.
As I read the agreement and the qualifications, the opportunities that the union is being given, could one assess that a right of first refusal is being given to the union on contracts?
I don't think I'd phrase it that way. The union would, of course, prefer a right of first refusal or a closed shop arrangement for contracting, but in South Dakota being a right to work state, the union has less ability to, how would I say it, impose its will on the utility companies. The purpose of the settlement, the underlying purpose of the settlement is twofold. One is to assure that for construction work done in South Dakota, we maximize hiring South Dakota residents in the course of construction. That's reflected in the settlement agreement. Number two is a little more esoteric. There is significant empirical data that demonstrates that construction work, complex construction work, pipeline work is a classic example of complex construction work. You know, a pipeline is a one-off machine. In the case of the Keystone Pipeline that covers thousands of miles, if you can visualize a custom-built machine that covers thousands of miles. It's amazing that can even be constructed and run. Gas infrastructure, transmission distribution, is not dissimilar to the Keystone-style pipelines and perhaps higher risk than than crude oil pipelines. There's empirical evidence that shows that union labor produces a safer product for less money than non-union labor. And it's all tied to training, principally apprenticeships, and the high-quality standards that go into union labor. You, like me, probably grew up with the idea that union labor is thought of as more expensive. So there's a resistance to the idea of having union labor. But the balance in that more expensive curve is the opposite side of the curve is better product for less money, even though you pay more to the laborer who works on the project. And that's the principal goal. What LIUNA wants is the opportunity to get in front of Mr. Byrd and his construction executive staff and demonstrate to them that our union-affiliated contractors can do a better job for less money on all construction components. Generation, LIUNA is not involved in wiring. That's the Brotherhood of Electrical Workers of America that handle wiring, so transmission of electricity is not part of our sphere. But the construction of all styles of generation, solar, wind, gas, if there's ever another coal plant built, coal, if there's a nuke plant built, nuclear, is within our aegis. And what we really want to do is persuade what will now be Bright Horizons that in South Dakota, our right-to-work state, we can provide you a better product for less money. And that's why we're here. That's what this is really all about. Get us in front to sell our abilities and services. You know, the three of us sat through hundreds of hours of pipeline testimony, a long stretch of which had to do with the quality of construction. The same agreement that the contractors signed with TransCanada for the construction of the TransCanada pipelines and for the construction of the Dakota Access Pipeline, and then Enbridge signed in Minnesota, is a national agreement that LIUNA is a party to, that union labor will be used in the construction of those pipelines, and it's recognized because of the skill and the safety. We don't have the ability to sell that very well in South Dakota because of the history of our state. The one thing I'll tell you is, you know that I'm a Rock River Republican, conservative, always have been. What you don't know is when I was 19 years old, I apprenticed to a fitters union from Omaha. Why did I do that? The union was constructing a pipeline on the University of South Dakota campus, and by working as a laborer for the fitters union, I could make about twice as much money as I could doing the other things that we did summertime while I was at the University of South Dakota. That's, well, more than a half century ago. And I learned in that work about the skills and the abilities of union labor, something I never comprehended before. I'd worked in a tractor factory in Sioux Falls as a welder when I was in high school. And I've carried that appreciation with me throughout my career, and that's why we're here, to persuade these two companies that it's a good idea to employ union labor. Long way around. Did I answer your question?
I'm glad to hear that was the long way and not the short way. And I mean that with respect to you. We've had the opportunity to engage in local government and state government and legislature, et cetera, et cetera. And I always enjoy the journey that you take us on with your with your answers.
Well, you were always a better negotiator than me. You know, I wanted to grab people by the lapels and explain how it's going to be, as opposed to you, who always had the ability to make deals.
Usually you give us a Shakespearean statement of some sort as you go through it, and I get to correct you on whether it's the right verbiage or not. You said on union, when you grew up, unions, the thoughts you had towards union, prevailing thought apparently was cost. Things would cost more. As I grew up, it was always quality, that if it were union made, it was stronger and better and would last longer and on and on. It was better quality. I also grew up with a strong belief in the right to work law. And as I looked at the agreement, it just seemed to give the unions a far upper hand on being able to, I don't want to use the word force or coerce, because it certainly does not do that, but to influence their opportunities for the first right of refusal. And so that's my question. If you could just simply state, does this in any way give them a first right of refusal?
I think no. I think it's a salesmanship effort. You know, the union movement is different than it was when we were young men. When we were young men, it was forceful, vocal, loud, measured by the automobile industry, primarily in the Teamsters. The union movement today is sell our skills and demonstrate to the consuming public, in this case Black Hills and Northwestern, that what we have to offer is a better product for a better price. And that's what we tried to tailor the settlement agreement to. I mean, sure, if I could have persuaded these two lawyers to sign an agreement that said we will never build anything without hiring union lawyers, or union labor, union lawyers would be even better. Without hiring union labor, if I could have persuaded them to sign that, I would have done that, representing my client, but they weren't about to do that.
A little Freudian slip is all right.
Yeah, they recognize we're a right-to-work state. I recognize that, and I appreciate and honor that. Montana is not. Montana is a different situation, and that's why our agreement is slightly different than Montana's.
Well, thank you very much. I appreciate your testimony. The difference for me when I was growing up, since you opened that door, was that I worked at a hot tar roofing company for $1.25 an hour, and Sandy worked at Morrell for $3.50 an hour.
There you are.
So a difference. Thank you.
You're always going to get a history lesson with Mr. Taylor, so thank you.
Well, your wife's steaks were better than the roofing, right?
Mr. Schaefbauer.
Yes, this is Logan Schaefbauer here. I may have misspoken earlier to a question from Commissioner Fegan. Our settlement stipulation with the joint applicants mentions informational filings. So I think the understanding was certain things would be informational filings, but maybe a question to the commission is, is it preferable that those informational filings be filed in the docket instead?
When I was asking the question, that was my preference. There are two other commissioners here, but that was my preference.
Any additional questions? Do you want motions, or do you want to discuss that issue further? Let's just go to motions and see what comes out of it. Motions. In GE 25-001, I move that the commission grant the joint motion for approval of 2 settlement stipulations and the stipulation for the entry of all pre-filed testimony and exhibits, and that the commission approve the joint application for approval of merger subject to the terms and conditions stipulated to by the settling parties. Discussion on the motion.
Mr. Chairman, are you allowing public testimony at this time?
Public comment comes at the end of the meeting, and we will get there.
Thank you.
So obviously, as I stated earlier, this is not something we do every day, and appreciate the opportunity to have evaluated this. Greatly appreciated staff thoroughly digging into this from the perspective of what the statute allows and understanding that, not going beyond that, and that you ultimately came up with settlements that protect South Dakota customers in the way that they need to be protected through this. I think there's 2 things that are really important to understand, I think, from the public's perspective. First is that as Northwestern moves forward, if we approve this, as Northwestern moves forward and Black Hills moves forward, we still regulate those individual companies, and nothing changes in that regard. And if things are happening with either of those companies that aren't right, we will deal with that, just like we always do. Nothing changes in that regard. The second thing that I think is very important to understand is what our statute says. 4934A36, and it says this commission shall. It's not permissive. It's not if you kind of want to. It says you shall approve these kinds of mergers unless there's a likelihood of significant adverse impacts to customers in this state. And I would submit that's probably a fairly low bar. But that's the bar the legislature has established. That's not something we establish. That's what the legislature has established. It's a fairly low bar, but it requires us to look at the really important things, and that's what staff has done. And so based on that, my conclusion is that this motion that I have made is appropriate today. Additional discussion, Commissioner Fegan.
Thank you. Staff, I'm so grateful that you really dug into this, because when I read this statute to begin with, is there an echo in the room? Oh, okay. Oh, it's just the air conditioner. Okay. Yeah, it's getting hot in here, right? When I read this statute, Commissioner already read it, Commissioner Nelson read it to us, but it was a low bar. So I was wondering what type of settlement stipulations you could bring to the table and sign to give better protection and actually a bonus benefit to our customers in South Dakota. So what did you do? You made sure, of course, the companies were separate, and they brought that, so you'll have separate rate cases in the future to protect both sides, Black Hills Energy customers and Northwestern Energy customers. The corporate presence. Black Hills Energy, when you decided to build your corporate office in South Dakota, thank you. And you put that in the stipulation. And you also put a stipulation that there will be a presence for 5 years in Sioux Falls with Northwestern Energy. So I appreciate that. I also, sometimes I don't think we always understand the impact when you add another year for a rate moratorium. And that was another benefit that you added for our customers in South Dakota. And they don't, sometimes we just don't understand how many millions of dollars you have saved our customers. So here's another bonus benefit that you provided. Of course, I love it that you did not allow any merger costs for any ratepayers. That is all shareholder costs. And so you protected us again. And so when I look at this, I hope to see operations efficiencies that Brian Bird talked about, and that it is operation efficiencies with a high level of customer service. Thank you for the smile. So I appreciate that. What I also see is the strength going to Wall Street. We are making two companies in South Dakota have a significant, I would say, strength financially in aspects going to Wall Street and getting lower costs of capital. Another bonus for our customers. But the staff had to do this, realizing that we didn't have a lot of authority to ask for any of that, but you did anyway. And so I certainly appreciate what you've done. You've protected South Dakota customers. We've done it according to the law, what can be upheld in the Supreme Court, and I appreciate that.
Additional discussion.
Mr. Chairman, I do like this agreement. I like it very much. And I especially appreciate the work that staff has done on this. I am very pleased. I look at the different portions of it, the nuances that are associated with that. I know it took a tremendous amount of collaboration and negotiation, and I congratulate you on accomplishing that. This is an historic agreement, and you have made it a good agreement. I like the ring fencing protections. I like the most favored nations, the golden parachutes, the fact that the citizens will not be affected by that, the financial strength, potentially lower costs will be lower than they otherwise would have been. This is well, you've given us a package. Obviously, working with the other folks, I'm congratulating what I'll say is our team, and appreciate the work that the other, whether it's the labor unions or Northwestern or Black Hills, the fact that you were willing to put together a package that would be acceptable to us, and that would be to the greatest benefit of the citizens of South Dakota. Bright Horizons, I guess, is a good name. I hope that the horizons are bright, and that this particular agreement has made that an option that is most likely to succeed for all of us. And we've had some history and some challenges when I very first started back in '02, and I'm glad to see that the tremendous turnaround and what has become an outstanding, just absolutely outstanding organization. And so I look at the faces of folks out there that were part of this, the history of it, and that you've done a marvelous job, all of you. I sincerely, as a commissioner, appreciate it. Thank you, Mr. Chairman.
Additional discussion. Hearing none, all those in favor will vote aye. Those opposed, nay. Commissioner Hanson.
Aye.
Commissioner Fegan.
Fegan votes aye.
Nelson votes aye. The motion carries. And now is the time appointed on our agenda for public comment, and Mr. Frank Klochek is online. Frank, go ahead.
Well, thank you, Mr. Chairman, and members of the commission, staff, and Bill Taylor, one of my idols. I was hoping that you would get public testimony today before you voted on this, but that being the case, many people have come to me with this over the years, and I had hoped for an extension of the process. You're not even a year into this, and this is a very major decision. If this and now it is adopted, it's going to mean a super monopoly in the energy industry. It will be very similar to the size of the Enron company, and you do have this in writing, and I believe you have it before you. If not, the staff has it. Much ado is given to the fact that the CEO will retire and that the other will take over. That is not the issue. The issue is how the boards will be selected in the future. Will they have a strong board or a strong chairman, and not who the CEO will be? We all remember the huge scandal several years ago with Northwestern Public Service. We certainly don't want a return of that. I'm requesting that the former Consumer Affairs Division of Black Hills Power and Light be reinstated in Rapid City. Public access to the building be allowed and not blocked as is currently done. Request that there be a consumer affairs offices throughout the Black Hills Power and Light and Northwestern Public Service territories in and out of state. Transparency is very important. Short years of public service and involvement in leadership in various organizations, the biggest problem was executive decisions and sessions without public or stakeholder involvement. Decisions were made on important issues that had nothing to do with personnel issues, as is supposed to be done. Data centers are a huge concern. The data center proposal named Jade as a rural location 10 miles from Cheyenne captures 3,700 acres of Wyoming land, will certainly cause huge energy consumption issues. Although initial usage is 1.8 gigawatts, 1 gigawatt power 750,000 homes, the final usage is 10 kilowatts, which will be enough usage of 10 nuclear power plants. Water usage, evaporation, and other factors a huge concern along with electrical consumption. What will be the impact on consumers when these data centers are located in our area and in this issue is a huge concern. Will the mega merger monopoly be efficient? Will it be too big to address repair and replacement lines? Will Black Hills Power and Light and Northwestern be able to service their areas effectively? Will they treat investors, employees, and customers fairly? Several weeks ago on a Sunday, an employee of Northwestern Energy from the Yankton office answered the call in an emergency situation north of Scott. When the power went off, the life alerts went off on an elderly couple. The man named Dan Albrecht, a key Northwestern employee from Yankton, was on hand at the location 45 minutes after we called to restore electrical power. What could have been a life-threatening situation became a life-saving one. Will dedicated employees like Dan be able to respond in the future in these situations in a timely fashion? And could you please let me know when we're getting like 30 seconds or a minute away?
Well, we're kind of past the 3 minutes, but I'll give you another minute, Frank.
Okay, Montana PUC appears to be hesitant to approve the loss of workers. Montana provides a large amount of generation. Nebraska recently approved the merger, and the rates will not increase. There is already a flat $11 a month consumer increase, which will mean $132 yearly increase to consumers. We do have documentation in the packet that we gave you about a story in Montana. Wyoming is already experiencing power shortages due to the increased demand from the data centers. Conclusion, I do ask for a pause, but that absolutely does no new good now, and approve of this merger to get more public testimony and more documentation from the two companies. One of the duties of a PUC commissioner is to conduct hearings and investigations on utility practice and policies. Thank you for doing so and considering a pause and trying to do your due diligence in this matter. And I do have a personal privilege, if you have time for that, Mr. Chairman.
I'll give you 20 seconds, Frank. Go ahead.
Oh, check days. So we were planning on coming up Monday, and of course it's the Bohemian National holiday, and we didn't see your notice to cancel the meeting. And so we come up on Saturday and Sunday we came up, looked at it, got ready to go. Monday we went up and found out it was canceled. But anyway, neither here nor there. Check days is great. 2 years ago, Chris, Chairman Nelson, we talked about this hearing that they were having over the pipelines. And you told me something that has stuck in my mind for 2 years. You, in the best of the halls, we were buying our favorite kolaches, your wife and I and you. And Chris says, Frank, we have to follow the law. and we were talking about that pipeline issue. And Chris, here's my challenge to you, and it's with all due respect to your staff. It's not that we follow the law. It's how we interpret what the law says that we follow. And with that, our interpretation and the staff and the lawyers' interpretation of that law. So with that, again, I thank you for the opportunity to testify. Good luck on your retirement. And I wish you the very best, Commissioner Hanson, Senator, Mayor, and distinguished gentlemen. Thank you for your service to the people of South Dakota. And thank you, Mr. Chairman, for this time.
Yep, thank you, Frank. And I'm just going to make 2 quick points. One that I didn't point out as we were talking about the language of the statute. The statute requires the commission to act on the application within 180 days. And so this is not the type of thing that we could put off for an extended amount of time. And the second point that I would like to make is that nothing we have done here today changes rates for Northwestern customers or Black Hills customers. Changing rates would require a separate proceeding, which we are all very familiar with. With that, is there anything else for the good of the order? Is there a motion?
Move to adjourn.
All those in favor will vote aye. Those opposed, nay. Commissioner Hanson.
Aye.
Commissioner Fegan.
Egan votes aye.
Nelson votes aye. Motion carries. We are adjourned.
SDPB brings South Dakotans together, telling the stories that unite small towns, big ideas, and the people who make our state shine. Good, useful, and full of wonder. SDPB. SDPB shares the voices and experiences of South Dakotans, preserving our stories, our culture, and our sense